Listen, there are more things that are happening in Canton right now. We're starting to learn more about what went on in jury deliberations. I don't know if you guys remember, but I think it was News Nation. They were one of the first to report that, well, the jury, they moved pretty quickly from the higher charge, which was second-degree murder. It seems like they may have been split on the manslaughter. And based on the note that was written from the jury to the judge, I think they said a handful of them thought that Karen Read was guilty, and then the rest just thought that the state didn't meet beyond a reasonable doubt. So I had reasons to believe, okay, there could have been more than maybe like a couple people that thought that she was guilty of manslaughter, and that was the one that they were, that they were arguing about, and that's why it came to a mistrial. But we are starting to learn that, well, it seems like the jury, some of them are coming out, they're speaking with the defense, I think, and they are saying that, like, yeah, we cleared Karen of murder, second degree murder, and we also cleared her for the third charge as well, which I think was maybe like her being under influence. I think that's what it was. Now, the one that they fought over was probably the manslaughter one. Now, we're going to read the document here, but before that, things that are happening in Canton. Well, let's start with Mr. Michael Proctor, who was the lead investigator. He testified on the stand, and he's the one who had, a nice way to put it, unsavory text messages about Karen Read. And he was texting family members, friends, and even people within his own unit, his coworkers, supervisors in some of these group chats. Yeah, really fucking bad. Michael Proctor was put on leave pretty quickly after the mistrial was announced. However, I think he was put on leave with pay. And let me pull up this article really quick just so I don't butcher anything. State police formally transferred Proctor out of the detective unit assigned to the Norfolk District Attorney's Office, which prosecuted Read's case, and moved him to Field Services Division of Trooper H. However, an agency spokesperson previously clarified that Proctor turned in his equipment and is not able to function as a trooper for the time being. An internal affairs investigation began into Proctor's conduct is ongoing, and the trooper faced a duty status hearing on Monday to determine whether he should remain on duty or face suspension. According to state police, a board of 3 officers recommended Proctor to be suspended without pay. Colonel John Mon Jr. accepted the board's recommendation, making Proctor's suspension effective immediately. I don't know if you guys saw the footage of Proctor where I think the newspaper were trying to get him to interview. They were on his lawn and he was like yelling at them to get the F off his lawn. His wife was there. It seems like the wife is supporting him, and they probably think that Karen Read is guilty. Anyways, he's not the only one that people are looking at. There's also, Kevin Albert. Who was Kevin Albert again? Kevin Albert is the brother of Brian Albert. Brian Albert is is his house where John O'Keefe's body was found. And now the interesting thing about Kevin Albert was, it seems like there was a night of drinking that him and Proctor, they were working on a cold case or something like that. They went out drinking, and I think the next day, Kevin was texting Proctor like, oh my God, like, did I leave my badge there? Is my gun there? Yeah, that sounds pretty fucking bad if you don't know where your badge and your gun is. So he has been placed on leave as well, I think with pay. Kevin Albert, the Canton police officer, revealed to be communicating with lead Massachusetts State Police investigator Michael Proctor during the investigation ahead of the Karen Read murder trial, has been placed on paid administrative leave. Quotations from the Canton police chief. I can confirm that Detective Albert was placed on administrative leave with pay as of June 13th, pending an investigation relating to the testimony of Trooper Proctor, the Karen Read trial. So we are, I don't know, man, the town of Canton, things are shaking up over there. Oh boy. Lastly, I want to go to the motion to dismiss. Now, the defense, they are like, well, if the jury cleared Karen of, they acquitted her on the second degree murder and third charge, well, isn't she technically acquitted, I guess, right? Now, they had an issue with the, I guess maybe the manslaughter part, but it would be weird to try her again. The state very quickly, and I wonder if they regret it, because remember I said it felt really hasty that the state quickly said, oh, we're going to go after her. We're going to try her again. Yeah, we're going to do that. I'm like, oh, do they know what the jury polling was? Do they know how many people thought she was guilty, not guilty? Did they feel like they had a strong case to try all over again, especially with Proctor on leave? I don't know. I just feel like it was just a hasty thing to come out and say, we're going to go after Karen Read again. I feel like they should have waited. Okay, because now I think it kind of looks bad. So let's read the defense's motion. And I think they were able to maybe get a hold of 3 jurors, or maybe 3 jurors contacted them and was like, hey, like we didn't feel right about this. I haven't read this yet. I've just heard some rumblings, a lot of rumblings about this. So let's read it together. Also, hi guys, we're watching the Alec Baldwin trial this morning. Opening statements should be up on my channel by now if you guys missed it this morning. Okay. Defendant Karen Read's motion to dismiss. I believe this was filed initially on July 8, and then they added like a supplemental, maybe, because another jury came out and reached out to them. Now comes the defendant Karen Read by and through undersigned counsel, and hereby moves this honorable court pursuant to 5th, 6th, 14th Amendments of the United States Constitution, Article 12 of the Massachusetts Declaration of Rights, to dismiss counts 1 and 3. Currently pending against her on the grounds that the jury reached a unanimous, so everyone voted on this and agreed, decision to acquit her on those charges. And alternatively, because there is no manifest necessity supporting the declaration of a mistrial with respect to the charges on which the jury had agreed that Ms. Read was not guilty, and that therefore a retrial on such counts would violate double jeopardy protections of both federal and state constitutions. Oh gosh. I mean, I kind of want to go back and look at the jury form and maybe look at the judge's instructions for the jury. It could have been confusing for them, where they thought that, okay, well, maybe we had to be unanimous for everything to tell the judge that, okay, we came with, a semi-verdict. Oh gosh. Because I wish there was just more communications. Like whoever was writing those juror notes, I think they seemed very smart, knew what they were doing, knew what they were writing. I wonder if they could have just been like, hey, we came to a unanimous vote on counts 1 and 3. 2 is the one that we're struggling with. 2 is the one that we had issues with. Because based on what the jurors were writing, the notes to the judge that was being read out loud, it seems like, I don't know, to me, it kind of seems like they couldn't agree on anything. That's what I was thinking. I thought they were stuck on like all of them, maybe. There's a good amount of people who thought she was guilty on murder too. There's a good amount of people who were like weren't sure and wanted to do manslaughter instead. There was a good amount of people maybe who didn't want to do, who didn't think she was guilty of anything. Or maybe some people were like, a little bit stuck on count 3. I don't know, but it seems like they were pretty fucking close if they were able to unanimously agree on counts 1 and 3. That's pretty huge. The ancient right to a jury trial is no more procedurally formal, but rather a fundamental reservation of the people of the American power to the American people. By requiring the executive branch to prove its charges to a unanimous jury beyond a reasonable doubt, the 5th, 6th Amendments seek to mitigate the risk of prosecutorial overreach and misconduct, including the pursuit of pretended offenses and arbitrary convictions. Prominent among the reasons, colonists cited the Declaration of Independence for their break with Great Britain, with the fact Parliament and the Crown had deprived them in many cases of the benefits of the jury by trial by jury. Sorry, the warping is screwing my mind right here. After securing their independence, the founding generation sought to ensure what happened before would not happen again. As John Adams puts it, the founders saw representative government and trial by jury as the heart and lungs of liberty. It follows that a jury acquittal is entitled to the utmost respect in our criminal justice system. The double jeopardy clause provides that no person shall be subject for the same offense to be twice put in jeopardy for limb or life or limb. The clause guarantees that the state shall not be permitted to make repeated attempts to convict the accused, thereby subjecting her to embarrassment, expense, ordeal, and compelling her to live in a state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, she may be found guilty. So, that makes sense, right? If someone is found, they're acquitted of something, you can't keep trying them over and over again. However, this one seems like a very special case. I'm very excited to see how this unfolds. Because, technically, I guess she was acquitted because they all unanimously agreed, but technically not because they couldn't agree on the second. It's like, yeah, that's wild to me. I just wonder if there's a way they could have done better in jury instructions where that could have been indicated for the judge to know. Oh gosh, I don't know. I just feel like there's just so much. If I was a jury, I would be, it's like, I don't know, I would just be so disappointed and disturbed, I guess. Like, remember how the judge was like, okay, I'm not going to make you guys do that. Y'all are free. Y'all can go. If I was in the jury, I'd be like, wait, but what about count 1 and 3? We all agreed on that. What's up with that? But, Judge Beverly's kind of fucking scary. Maybe they didn't want to speak up at that time. Perhaps the most fundamental rule in the history of double jeopardy jurisprudence has been a verdict of acquittal could not be reviewed on error or otherwise without putting a defendant twice in jeopardy and thereby violating the Constitution. Here, the very day of mistrial was declared, undersigned counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors indicating that in no uncertain terms that the jury had affirmed 12-0 agreement that Ms. Read was not guilty of 2 of the 3 charges against her, including the charge of murder in the 2nd degree. Given the central importance that acquittal have held in our criminal justice system for hundreds of years, the defense respectfully submits that the jury's unanimous agreement precludes re-prosecution of Ms. Read on counts 1 and 3. I wonder if this could have been cleared in jury instructions, and if any way could the defense bear a fraction of fault for that? And mandates dismissal of those charges. Alternatively, to the extent the court believes further factual development is required, the defense respectfully requests that a post-verdict inquiry be held on the issue, and that the court authorize defense counsel to seek additional proof from the jurors regarding having their unanimously acquitted the defendant of 2 to 3 charges against her prior to indicating to the court that they could not reach a verdict on the 3rd charge alone. Background. June 9, Ms. Read was charged with 3 separate indictments with murder in violation of MGL. Count 1, vehicular manslaughter in violation of MGL. Count 2, leaving the scene of personal injury or death in violation of MGL. A jury trial began on April 16th. On June 25, 2024, the jury began deliberations. July 1, when the jury presented a note to the court, all counsel were ordered to the courtroom. The note was presented to counsel for review. Rather, the court indicated that the jury was at an impasse. Once the jury was seated, the court then read the jury note verbatim in open court, and without providing any opportunity for defense counsel to be heard, the court declared a mistrial and excused the jury. In short, neither defense counsel nor the defendant consented to the mistrial, and the court never ascertained from the jury whether its deadlock was in relation to 1, 2, or all of the charges in the indictments. Could they have still spoken up, though, even though Judge Beverly did say pretty quickly, like, okay, I won't do that for you guys. You guys are free to go. Like, could they have interjected afterwards? The following day, on July 2nd, 2024, Attorney Jackson was contacted by a juror in this matter, Juror A, who stated that she wished to inform him of the true results of the jury's deliberation. According to Juror A, the jury unanimously agreed that Karen Read is not guilty of count 1, which was second-degree murder. Juror A was emphatic that count 1, second-degree murder, was off the table, and that all 12 jurors were in agreement that she was not guilty of such a crime. The jury also unanimously agreed that Karen Read is not guilty, of count 3, leaving the scene with injury and death. Gotcha. Okay. So, sorry, I think I got that one mixed up. I thought count 3 was just her just being, intoxicated. So, the one that was in contention is the manslaughter one. Another day later, on July 3rd, Attorney Yannetti was contacted by 2 different individuals, informant B, informant C, who had received information from 2 distinct jurors, hereinafter Juror B and Juror C, both of whom were part of the deliberating jury on this case. Yannetti affidavit is attached. Informant B sent Attorney Yannetti a screenshot he and she received from someone, hereinafter intermediary B, of text messages that intermediary B had received from Juror B. In that screenshot, Juror B texted the following to intermediary B. It was not guilty on second degree and split in half for the second charge. Okay. I thought it was I don't know why. I thought it was 4, I don't know, maybe like 4 or 5 split, like 4 to 8 split or a 5 to 7 split. Interesting. So we're split just in half. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. Informant C had been in contact with another individual, intermediary C, who was a coworker and juror, friend of Juror C, and joined a Zoom meeting during which Juror C discussed the trial. Informant C sent Attorney Yannetti the below screenshots of his or her text messages with intermediary C regarding what Juror C revealed in the Zoom meeting. Intermediary C, no consideration for murder 2. Manslaughter started polling at 6-6 and then deadlocked. 4 no, 8 yes. Informant C, interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on the count and hung on the remaining charges? Goes back to the jury verdict slip that was all confusing. Intermediary C, She should have been acquitted. I agree. Yes, the remaining charges were what they were hung on, and that instruction paper was very confusing. But did they ask clarification from the judge or the attorneys? I don't think so. I remember when they were called, I do remember Jackson wanting to clarify the jury instruction. I think he wanted to show that instead of just saying guilty, 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 he wanted to show that there was an option for guilty and then not guilty, guilty, not guilty, guilty, not guilty, I think. Because the judge was like, well, if they didn't check guilty, then we would assume it's not guilty. It's like, yeah, but it's like probably better to have it checked, just to make it super effing clear. I remember seeing the battle between the judge and Jackson, and then she like pulled Yannetti into it. And then at some point she relented and was like, you know what? Okay, fine, I'll change it. But, usually it's done this way. Yannetti, you should know because you practice here in Massachusetts. Yannetti's like, I've never seen it like this before. But I don't remember the jury asking for clarification. I do remember when they asked for they asked for the search and rescue team. They wanted the report. I remember they asked for that, which they weren't given. And then subsequently, it was just them saying to the judge that, they couldn't agree, that, they tried, they exhausted they exhausted every measure. And that's what I remember. Because I would assume if the jury wanted to ask for clear instructions on the instruction paper, that would have to be done in open court. It wouldn't be something with just them and the judge. It would have to be like everyone has to be in on there. Argument. The jury's unanimous conclusion that Ms. Read is not guilty on counts 1 and 3 constitutes an acquittal and precludes a re-prosecution. What constitutes an acquittal is not to be controlled by the form of action in question. Rather, the court must determine whether the action actually represents a resolution, correct or not, or some of all of the factual elements of the offense charge. The mere presence of absence of check marks on a form is not dispositive. Here, the attached affidavits by attorneys Jackson and Yannetti reflect statements by 3 deliberating jurors that the jury had reached a final unanimous conclusion that Ms. Read was not guilty in counts 1 and 3. There is nothing tentative about the jurors' statements. To the contrary, they were definitive in describing the result of the jury deliberations. Okay, so we're going to read their affidavits. The Supreme Court's decision in Bluford is not in the contrary. There, a juror had reported during deliberation that the jury was unanimous against the charges of capital murder, first-degree murder, but split on manslaughter. The court sent the jury back to continue deliberation. When the jury remained unable to reach a verdict, declare a mistrial. Supreme Court rejected the defendant's argument that the double jeopardy clause prohibited re-prosecution for capital and first-degree murder. In doing so, the court heavily relied upon the lack of finality on the juror's report. The jury's deliberation had not been concluded and went back to the jury room to deliberate further. Here, by contrast, the juror's statements reflect a final determination that persisted through the end of deliberations. Even assuming arguendo, and contrary to the foregoing, this court finds that a retrial would not be prohibited under Bluford. This court can and should afford broader protection under Massachusetts state law. Unlike the United States Constitution, the Massachusetts Declaration of Rights does not include a double jeopardy clause, but our statutory and common law have long embraced the same principles and the protections. B. Re-prosecution is independently barred because there was no manifest necessity to declare a mistrial on counts when the jury was unanimously agreed. I guess I heard that they do polling for sure when there is a verdict, but why not just do a polling when there's no verdict, right? Why not? Just do the polling. I don't know. There's probably some good explanation for that, maybe. I don't know. Or Massachusetts, maybe they just, I don't know. There's some, I feel like there are things in Massachusetts where they do things, or sorry, not just Massachusetts. I'm talking about Judge Beverly's courtroom. I don't know, man. She be doing things kind of a weird way sometimes, in my opinion. But the double jeopardy clause affords a criminal defendant a value of right to have her trial completed by a particular tribunal. Thus, where mistrial is entered without the defendant's request or consent, retrial is impermissible unless there is a manifest necessity for a mistrial. Here, Ms. Read did not consent to the declaration of a mistrial, but they also didn't say anything, though. They didn't say anything. Judge declared mistrial. It ended there, and then everyone got up, hugged each other. I don't know. They didn't say anything. Could they have said something, or would the judge been pissy at them? See Alan Jackson affidavit, rejecting argument that the defendant consented to the declaration of mistrial because he did not object when the judge ordered the case dismissed. Oh, okay. Because he did not object when the judge ordered the case dismissed. Okay, so they're citing a case law right there. Absent the defendant's consent, state and federal double jeopardy protections bar, as a general rule, retrial of defendants whose initial trial ends ... without a conviction. The rule is rooted in the importance of the defendant of being able, once and for all, to conclude her confrontation with society through the verdict of tribunal she might believe to be favorably disposed to her fate. Accordingly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on Commonwealth. Before a court declares a mistrial for manifest of necessity, 1. Counsel must have been given full opportunity to be heard. 2. The trial judge must have given careful consideration to alternatives to a mistrial. Here, defense respectfully submits the lack of opportunity to be heard alone dispositive. Upon receiving a jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, unexpected, neither preceded nor accompanied by discussion with counsel. Finding no manifest necessity where no opportunity was given to counsel to argue the propriety of the question or the necessity of a mistrial. Finding no manifest necessity where the trial judge first ruled that he was going to declare a mistrial and then, after almost as an afterthought, unenthusiastically asked whether counsel objected. The record is independently lacking the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. I think everyone just assumed they were deadlocked on all of them. I mean, honestly, when I read the note, it seems like they were very divided. It didn't seem like they agreed on count 1 and 3. It just seems like they were just divided as heck. Had the court done so, the jury articulated its verdict consistent with the statements of jurors A, B, C. The double jeopardy implications would have been clear and decisive. Indeed, with virtual unanimity, the cases have applied the collateral estoppel to bar the government from relitigating the question of fact that was determined in defendant's favor by a partial verdict. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon when the jury has reached agreement. The Supreme Judicial Court's holding in Commonwealth v. Roth, the court should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. As Roth Court acknowledged, inquiry concerning partial verdicts on lesser included offenses that have not been separately charged carries a significant potential for coercion. Coercion is a hard word for me to pronounce sometimes. Declining to require court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses where, under Arkansas law, the jury's options were limited to 2, either convict on one offenses or acquit on all. Such inquiry in effect implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here the jury was asked to return 3 separate verdicts on 3 separate counts. In this circumstance, where the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is straightforward, and the defense contends constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Indeed, the Supreme Judicial Court has explicitly stated where a complaint or indictment in multiple charges multiple crimes, a general verdict could be returned as to one of the counts, despite deadlock on the others. C. Alternatively, the defense is at least entitled to conduct post-verdict inquiry. Undersigned counsel did not initiate the communication with jurors A, B, or C, which result in disclosure information that is memorialized in counsel's affidavits that are appended to this motion. Should this court find that further factual developments required, the defense respectfully requests that the court conduct a voir dire of the jury and or evidentiary hearing to substantiate the existence of an acquittal. Should the court seek the affidavit of each of the jurors, A, B, and C, the defendant asks for the court to authorize undersigned counsel to initiate contact for the sole purpose of asking each juror whether the jury had unanimously agreed the defendant was not guilty on counts 1 and 3. The Supreme Judicial Court has held that because of the importance of the issue, juror bias is a legitimate subject for post-verdict inquiry. It is similarly a fundamental tenet of our system of justice that a defendant may not be retried for a crime in which she was previously acquitted by the jury, and the defense submits a post-verdict inquiry is equally warranted in the present context. Just as the court in McCallop, I don't know how to pronounce that, approved questions as to the existence of racial bias, questions about a matter more attenuated for the content of deliberation, whether the jury had unanimously concluded that Ms. Read was not guilty on 1 and 3 does not invade the heartland of jury deliberations, but preserve the defendant's precious rights to a favorable outcome of a jury trial and the protections of double jeopardy clause and its related state judicial protections. Conclusion. For the foregoing reasons, Ms. Read respectfully requests this honorable court issue an order dismissing counts 1 and 3. Now let's go to their affidavits. Yannetti. July 3rd, 2024, I received communications from 2 different individuals, informant B and C, who received information from 2 distinct jurors, Juror B and Juror C. To my knowledge, informant B and informant C do not know each other. On July 3rd, informant B sent me a screenshot she received from someone of text messages that intermediary B had received from Juror B. And that screenshot, Juror B texted the following to intermediary B. So I'm going to read this part again. It was not guilty on second degree and split in half for the second charge. When the judge sent us back with that Hernandez thing to look at the other side, it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left. Based upon the first name of the juror B given to me by informant B, I believe I'm able to positively identify which juror he or she was and confirm that he or she was a deliberating juror. On July 3rd, informant C contacted me saying that she personally knows Juror C. They used to work together. Informant C and Juror C also have a mutual friend, hereinafter intermediary C, who is a current coworker and friend of Juror C. Informant C told me that he and she had posted something about Karen Read case on Facebook on Monday, July 1. He and she told me that she believes that post led intermediary C to text her, and inform her that Juror C was a deliberating juror on the case. Informant C told me that they thereafter reached out to Juror C via text message and discussed their experience as a juror in a very general terms. They discussed what an exhaustive experience it was and that Juror C was relieved that it was finally over. Intermediary C told informant C that Juror C, that's kind of confusing, would be participating in a Zoom meeting with a number of friends to discuss what happened with the trial. Today, informant C sent me 3 screenshots of the text message exchange that they had with intermediary C. Informant C told me that intermediary C was reporting to them during this exchange with what Juror C had revealed during the Zoom meeting. The text message exchange reads as follows. Intermediary C. Quotations. No consideration for murder 2. Manslaughter started polling at 6-6 and then ended deadlock at 4 no, 8 yes. 4 no, 8 yes. So 8 people voted for manslaughter, 4 people voted no manslaughter. She was very consistent with the fact that they could only consider things that were admitted into evidence. Ultimately, they voted no because the cause of death was twofold of hypothermia and head injury, of which they were convinced that the vehicle did not cause both. The whole jury felt very intimidated by Higgins' presence at the end. Higgins. Brian Higgins. ATF guy, right? They were not sure what they were going to do. They're going to lay low for a couple of days and see where it takes them. Hasn't ruled out anything. The jurors all have a group text going. Informant C. Interesting. If it was no consideration for murder 2, shouldn't she have been acquitted on that charge and hung on the remaining charges? Goes back to the jury verdict. Slip was all confusing. Sorry, let me read that again. And hung on the remaining charges. Goes back to the jury verdict slip that was all confusing. Intermediary C. She should have been acquitted, I agree. Yes, the remaining charges were what they were hung on, and the instruction paper was very confusing. Again, this is intermediary C, who knows Juror C. This is not really coming from the juror directly, but I think some of these are probably copy-pasted from their conversation with Juror C. I think maybe some of them are like word for word from Juror C. They had 3 screenshots of a text exchange that they had with intermediary C. Okay. But this is not the juror saying it directly. This is someone who's friends of Juror C. But I don't know, they might have copied and pasted some stuff. What a great experience for them. Amazing that they let the Alberta in the last day. They felt very honored to be part of it. They was redacted physical description of Juror C. Everybody else was from a professional walk of life. They all got along and never heated. They agreed to disagree and respected each other. That's the way it should be. Oh, knew it was an intelligent jury. Maybe I knew it was an intelligent jury. They will be studying this case in law programs for years to come, i.e. how not to investigate and try a case. They all agree on no for murder 2. They should make it clear to the DA. And the court is basically a case of double jeopardy if she is retired on that charge. Based on the description Juror C given to me by informant C and confirmed by the redacted content of the above text message exchange, I am able to positively identify which juror they were and confirm that they were a deliberating juror. Okay, Mr. Jackson. Jackson was contacted by Juror A, true name and identity withheld to maintain anonymity. Based on my conversation with Juror A, and that's a juror's description of who they are, where they are seated, and search and identifying information like name and occupation disclosed during the voir dire process, I was able to positively identify which juror they were. Juror A told me that they were seeing inaccurate reports about the split among the jurors related to the mistrial that the court declared the day before. Juror A stated that they wished to be respectful of the privacy of the deliberative process, but did wish to inform me of the true results of such process. Juror A indicated that they believe it is important to disclose such results because they believe that the results significantly impact Ms. Reed's rights. Juror A told me that the results of deliberation was that the jury unanimously agreed that Karen Reed is not guilty of count 1, second-degree murder. Juror A was emphatic with count 1, second-degree murder, was off the table, and that all 12 jurors were in agreement that she was not guilty of such crime. I guess, like, were they just scared to write that in the note to the judge? Or did they think that they weren't supposed to write that or shouldn't write that? I feel like you would just write it just in case, and then it's up to the judge if she wants to read it or not, you know? Juror A told me that shortly following the determination regarding count 1, the jury also unanimously agreed that Karen is not guilty of count 3, leaving the scene with injury and death. On July 1, 2024, when the jury presented the note to the counsel, all counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated, wait, hold on. I thought the judge read it verbatim. Is she trying to say that are they trying to say the judge didn't read it verbatim? July 1, the jury presented a note to the court. All counsel were ordered to the courtroom. The note was not presented to counsel for review. Rather, the court indicated the jury was at an impasse. But she read the note. It seemed like she read it verbatim. Once the jury was seated, the court then read the jury note, verbatim, in open court, and without providing opportunity for the defense counsel to be heard, the court declared a mistrial and excused the jury. Oh, okay, gotcha. Sorry, I was a little hung up for something for a second there. So again, the same thing. Defense didn't have a moment to chime in on their thoughts and opinions. Karen Reed never consented to the mistrial. I mean, I don't know if they need to consent to a mistrial, though, but they probably need a moment to present their thoughts and arguments. Defense counsel was denied the opportunity to request the court inquire on which count or counts the jury may have been deadlocked, including lesser included offenses, and on which count or counts the jury may have arrived at a verdict. Nor did the court in its own inquire the jury foreperson on which counts the jury was at an impasse and whether the jury could or did not reach unanimous agreement on any of the other counts. Had the court so inquired, it may be clear that not guilty verdicts would have been recorded for count 1 and count 3, and Reed was denied her right to receive those verdicts of her favor. The foregoing is true and correct to the best of my knowledge and belief. And that's it. Oh boy. What a what a mess for the state DA. Oh goodness. I think I read a headline recently again saying that what did I Google? Karen Reed. It was like the state's they're gonna go after Karen Reed again. Karen Reed. Oh gosh. Karen Reed. Man, I think the state, they should have waited, man. They should have waited. Yeah, they should have waited Fourth juror confirms not guilty verdict. Let's see what Court TV says. So we have jurors A, B, and C. Okay, let me read this. I don't know if there's gonna be any new information on here. Zoom it up. Zoom it up. Zoom, 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 zoom. The attorneys for Karen Read now say a fourth juror has approached and confirmed the jury in her murder trial has reached not guilty verdicts on the two most serious charges. Oh boy. So on Monday, they filed a motion, supplemental motion. In a supplement to the motion filed on Wednesday, Jackson said that he was contacted by a fourth juror who reported that many of the jurors appeared uncomfortable with how things ended, wondering, is anyone going to know that we acquitted Karen Read on count 1 and 3? No one ever asked about these counts. In an affidavit attached to Supplemental, Jackson said the juror identifying juror D to protect their anonymity told me that he or she decided to reach out to me because they were uncomfortable with how the trial ended. They said the last day of trial was a whirlwind and everything happened so fast. They described the end of the trial as very confusing. Gosh, poor jurors. No public poll of the jury was performed in court, which means there is no official record of how the jury or individual jurors were inclined to rule. Oh, wait, is that going to be an issue? Because, could that be an issue? Because could it be like, since it wasn't officially recorded, then it's like, well, who knows if the juries are lying or if they really did acquit Karen Read of two of the serious charges, because it wasn't recorded then and at that time, right? Jesus, that sounds like crap. Despite that, Read's attorneys maintain that because the jurors who contacted them say they were unanimous in their findings that she was not guilty on 2 counts, because I wonder if the state could be like, oh, well, now the jury's tainted. You know, maybe they did outside research and, oh, Jesus. Okay, sorry. Despite that, Read's attorneys have maintained that because the jurors who contacted them say they was unanimous in their findings that she was not guilty in 2 counts, double jeopardy protection should be in place. Gosh, I don't know. Could there be double jeopardy if it wasn't officially recorded then? Jesus, what a headache. Should be in place and would prevent her from being prosecuted for the crimes again. Yeah, because the state said they're going to go after her. The Norfolk County District Attorney's Office, which prosecuted the case, has not filed an official response. I can't wait to hear from their response. Oh my goodness. For their response. The parties are due back in court on July 22nd to discuss the next steps. Okay, that's in 12 days. I am looking forward to hearing from them. Oh my goodness. What a whirlwind. From what the jury said. What a whirlwind indeed. So we got an update with Kevin Albert. Put on leave with pay. Proctor, initially leave with pay, but now leave with no pay. And we got 4 jurors that has come out that said that, hey, we cleared her of counts 1 and 3. Was undecided on the manslaughter thing. I don't know then. Interesting. I don't know. All these cases are so interesting because it just seems so unique. Remember with like the Murdoch stuff? The Murdoch stuff was like, oh, the trial's over. Okay, we're done. It's kind of quiet for a little bit. The dust settles. But then boom, all of a sudden Harpootlian and Griffin, they come out and do a press conference talking about how the clerk of court, engaged in some impropriety and was talking to the juries. And then we had a whole evidentiary hearing on that. So we'll see what happens with the Karen Read stuff. Jesus. All right, guys. Well, that's it for me today. I'm going to record the Alexa Treviso video now because there's some updates with that. And we don't know if her trial is going to happen next month. There might be some delays. We might have some issues. And it seems like the state, they're trying to appeal to the Supreme Court for to reverse the decision that the trial court made. So we'll see what happens with that. All right, y'all, have a good one. Don't forget to subscribe, comment below, join the Discord if you haven't already, and then feel free to stop by during our lives. We're going to be doing some lives with the Alec Baldwin trial, and we have there's a lot of stuff going on this month, but lots of crazy things. But guys, thank you so much and have a good one. Bye.